Hilario Rada v. NLRC. January 9, 1992. Facts. Petitioner's initial employment with this respondent was under a contract of employment for a definite period dated July 7, 1977. Copy of which is hereto attached and made an integral part hereof as Annex A, whereby petitioner was hired as driver for the construction supervision phase of the Manila North Expressway Extension, second stage, hereinafter referred to as MNEE Stage 2, for a term of about 24 months effective July 1, 1977. It is hereby understood that the employer does not have a continuing need for the services of the employee beyond the termination date of this contract, and that employee's services shall automatically, and without notice, terminate upon the completion of the above specified phase of the project. And that it is further understood that the engagement of his/her services is coterminous with the same and not with the whole project or other phases thereof wherein other employees of similar position as he/she have been hired. Paragraph 7. Petitioner's first contract of employment expired on June 30, 1979. Meanwhile, the main project, MNEE Stage 2, was not finished on account of various constraints, not the least of which was inadequate funding. And the same was extended and remained in progress beyond the original period of 23 years. Fortunately for the petitioner, at the time the first contract of employment expired, respondent was in need of driver for the extended project. Since petitioner had the necessary experience and his performance under the first contract of employment was found satisfactory, the position of driver was offered to petitioner, which he accepted. Hence a second contract of employment for a definite period of 10 months, that is, from July 1, 1979 to April 30, 1980 was executed between petitioner and respondent on July 7, 1979. In March 1980 some of the areas or phases of the project were completed, but the bulk of the project was yet to be finished. By that time some of those project employees whose contracts of employment expired or were about to expire because of the completion of portions of the project were offered another employment in the remaining portion of the project. Petitioner was among those whose contract was about to expire, and since his service performance was satisfactory, respondent renewed his contract of employment in April 1980. After petitioner agreed to the offer. Accordingly, a third contract of employment for a definite period was executed by and between the petitioner and the respondent, whereby the petitioner was again employed as driver for 19 months. From May 1, 1980 to November 30, 1981. The last extension, from October 1, 1985 to December 31, 1985, Annex E, covered by an amendment to the contract of employment with a definite period, was not extended any further because petitioner had no more work to do in the project. This last extension was confirmed by a notice on November 28, 1985, duly acknowledged by the petitioner the very next day. Culled from the records, it appears that on May 20, 1987, petitioner filed before the NLRC, National Capital Region, Department of Labor and Employment, a complaint for non-payment of separation pay and overtime pay. On June 3, 1987, Philnor filed its position paper alleging, inter alia, that petitioner was not illegally terminated since the project for which he was hired was completed. That he was hired under 3 distinct contracts of employment, each of which was for a definite period, all within the estimated period of MNEE Stage 2 project, covering different phases or areas of the said project, that his work was strictly confined to the MNEE Stage 2 project and that he was never assigned to any other project of Philnor, that he did not render overtime services and that there was no demand or claim for him for such overtime pay, that he signed a release, waiver, and quit claim releasing Philnor from all obligations and claims, and that Philnor's business is to provide engineering consultancy services, including supervision of construction services, such that it hires employees according to the requirements of the project manning schedule of a particular contract. On July 2, 1987, Petitioner filed an amended complaint alleging that he was illegally dismissed and that he was not paid overtime pay, although he was made to render 3 hours overtime work from Monday to Saturday, for a period of 3 years. On July 28, 1987, Filnor filed its Respondent's supplemental position paper, alleging therein that Petitioner was not a company driver since his job was to drive the employees hired to work at the MNEE Stage 2 project to and from the field office at Sto. Domingo Interchange, Pampanga, that the office hours observed in the project were from 7 a.m. to 4 p.m., Mondays through Saturdays. That Filnor adopted the policy of allowing certain employees, not necessarily the project driver, to bring home project vehicles to afford fast and free transportation to and from the project field office, considering the distance between the project site and the employees' residences, to avoid project delays and inefficiency due to employee tardiness caused by transportation problems. That Petitioner was allowed to use a project vehicle which he used to pick up and drop off some 10 employees along Epifanio de los Santos Avenue, on his way home to Marikina, Metro Manila. That when he was absent or on leave, another employee living in Metro Manila used the same vehicle in transporting the same employees. That the time used by Petitioner to and from his residence to the project site from 5:30 a.m. to 7 a.m. and from 4 p.m. to 6 p.m., or about 3 hours daily, was not overtime work, as he was merely enjoying the benefit and convenience of free transportation provided by Filnor. Otherwise, without such vehicle he would have used at least 4 hours by using public transportation and spent 12 pesos daily as fare. That in the case of Cuiva vs. Filnor Consultants and Planners Incorporated, Supra, the NLRC upheld Filnor's position that Cuiva was a project employee and he was not entitled to termination pay under Policy Instructions No. 20 since his employment was coterminous with the completion of the project. Issues. The Petitioner is a regular employee with 8 years and 5 months of continuous services for his employer, private respondent Filnor. The claims for overtime services, reinstatement, and full back wages are valid and meritorious and should have been sustained, and ruling. The petition is devoid of merit. Principles. Our ruling in Sandoval Shipyards Incorporated vs. National Labor Relations Commission, et al. Is applicable to the case at bar. We hold that private respondents were project employees whose work was coterminous with the project for which they were hired. Project employees, as distinguished from regular or non-project employees, are mentioned in Section 281 of the Labor Code as those where the employment has been fixed for a specific project or undertaking the completion or termination of which has been determined at the time of the engagement of the employee. The completion of their work or project automatically terminates their employment, in which case, the employer is, under the law, only obliged to render a report on the termination of the employment. In Cartagena's, et al. Vs. Ramago Electric Company Incorporated, et al., we likewise held that, as an electrical contractor, the private respondent depends for its business on the contracts it is able to obtain from real estate developers and builders of buildings. Since its work depends on the availability of such contracts or projects, necessarily the duration of the employments of its workforce is not permanent but coterminous with the projects to which they are assigned and from whose payrolls they are paid. It would be extremely burdensome for their employer who, like them, depends on the availability of projects, if it would have to carry them as permanent employees and pay them wages even if there are no projects for them to work on. It must be stressed herein that although Petitioner worked with Filnor as a driver for 8 years, the fact that his services were rendered only for a particular project which took that same period of time to complete categorizes him as a project employee. Petitioner was employed for one specific project